my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate the public on issues that prevail here, so please subscribe to our channel. Today we're going to talk about the impact of restraining orders, or TROs, temporary restraining orders, as it relates to domestic cases. Sometimes one person will succeed in convincing a judge to give a TRO, which essentially means you can't see your kids, at least for now. So number one, what do? You've got to obtain some clarity on what the TRO is about. The court does not just give injunctions and TROs willy-nilly. The court has to find that there's no adequate remedy law, and therefore it has to enjoin the activity. The court has to find that there's a basis for doing it without even having a hearing. That's why it's an ex-parte order. And in order to do that, somebody convinced some judge somewhere that there's a danger, that there is no adequate remedy law, that there is a possibility of irreparable harm. These are the buzzwords for someone to get a TRO. So for that to have happened, there must be something going on. So number one, you got to gain clarity on what the TRO elements are and what must have been told to the court, what has been filed with the court to establish a TRO environment so that the court could give such temporary order. Number two, and understand this, until you have a hearing that says otherwise, you're duty bound to comply with that order. Even if you say to me, well, gee, Mr. Goldman, the order is based on me supposedly doing something that never happened. So the underpinnings of the order are false. Nonetheless, you've got to comply with that order until such time as the court sets it aside. Now, the court will grant you a hearing on that, and your attorney can file a motion for a hearing on that to argue to the court what's true and what's not. And maybe the court in that situation will change its mind. Maybe the court will say, well, wait a minute, I was under impression X. Turns out X is not the truth. In fact, Y is the truth. So therefore, the court will set that order aside. But in order to do that, you've got to get that information before the court. You've got to document everything that's involved and comply with the court's order. Now, once you've complied with the court's order, but nonetheless you've documented what's going on, the court won't be distracted about you taking the law into your own hands because you're still complying. So your argument basically is, look, Judge, you gave an order. We have complied with the order. However, you need to set that order aside because the order alleges A, B, C, and D, no part of which is true. And that's how you sort of have to come forward with this. So that's your approach if you receive a TRO. Now understand this. The court doesn't like to give temporary restraining orders unless it feels that the children are in danger. Once it gives them, the court doesn't like to set aside its own orders, so therefore you have to understand what the burden of proof is with respect to that and what needs to be shown to the court in order to get it to set those orders aside. Now, if you have any questions about that, reach out and we'll be glad to help you out.